Losing a loved one is undoubtedly one of the most heartbreaking and difficult experiences any of us will ever face. When you are mourning, the last thing you want to worry about is complex paperwork. Yet, amidst the profound grief and the sharing of cherished memories, families are often confronted with daunting legal tasks, such as understanding the probate process. Probate can seem like an overwhelming and confusing maze of legal jargon, but you do not have to navigate it in the dark. Our goal today is to provide you with clarity, support, and a foundational understanding of what it actually means to probate a will, helping you find peace of mind during a challenging time. Many people think that once a will is read, the inheritance is immediately handed out, but there is a crucial middle step known as probate. Probate is the formal legal process of administering a deceased person's estate, ensuring their final wishes are honored according to the law. At its core, probate serves several vital functions. First, it officially validates the will, confirming it is the authentic, legally binding document. Once validated, the process immediately steps in to protect the estate's assets from theft or mismanagement during the transition period. Before any beneficiaries see a dime, probate ensures that all outstanding debts and final taxes are properly calculated and paid. Only after these obligations are cleared does the court authorize the legal transfer of ownership, officially moving property, funds, and assets into the names of the rightful heirs. Finally, probate provides a structured legal forum to handle any disputes. If family members disagree or someone contests the will, the probate court acts as a neutral ground to resolve conflicts fairly, ensuring the estate is settled exactly as the law requires. To understand probate, you must know the key players involved. Let us break down the 5 main roles. First is the decedent. This is simply the legal term for the person who has passed away and whose estate is being settled. Next is the executor, or personal representative. This individual, often named in the will, is tasked with managing the estate and guiding it through probate. Then we have the heirs and beneficiaries. These are the diverse individuals or organizations legally entitled to inherit the assets left behind. Overseeing this entire process is the probate court, the supervising authority that validates the will. Finally, we must account for creditors, those who are owed money and must be paid before any inheritance is distributed. Navigating the probate process might seem daunting at first glance, but breaking it down into a step-by-step guide makes it much more manageable. The very first step is filing a petition with the probate court. This official request asks the court to formally open the estate and appoint an executor or administrator to handle the deceased's affairs. Once filed, the second step is notifying all interested parties, including legal heirs, beneficiaries, and creditors, ensuring everyone has a chance to participate. Right after this, in step 3, the court steps in to validate the will. The judge confirms it meets all state legal requirements and is the true final testament. Moving on to step 4, the appointed executor must take inventory of everything the deceased owned. This means tracking down, securing, and accurately valuing all assets. Real estate, bank accounts, investment portfolios, and valuable family heirlooms must all be carefully documented and appraised. Step 5 is arguably the most crucial for clearing the estate, paying outstanding debts and taxes. Before any beneficiary sees a dime, the executor must use the estate funds to settle valid creditor claims, pay final medical bills, and file the deceased's final income and estate taxes. Finally, we reach steps 6 and 7. After all debts are cleared, the executor distributes the remaining assets exactly as the will dictates, or according to state law. The executor then submits a final accounting. Once approved, the judge formally closes the estate, bringing the entire legal process to a peaceful resolution. One of the most common questions about probate is, how long will this take? The timeline depends heavily on the estate's complexity. A simple estate with clear instructions might conclude in about 6 months, but complex estates with multiple properties, business interests, or family disputes can take well over a year. Fortunately, if you are dealing with a smaller estate, many states offer simplified probate procedures. These expedited processes can significantly reduce both the timeline and the administrative burden for the family. Beyond time, there are several costs to consider. A typical probate involves attorney fees, court filing fees, executor compensation, appraisal fees for evaluating assets, and potential bonding fees. These costs can quickly add up, and they are typically paid directly from the estate's assets. Your probate experience largely depends on whether you pass away with or without a valid will. This is the difference between dying testate and dying intestate. Imagine a family at a crossroads, where one path is clearly mapped out and the other is completely uncertain. Dying testate means you have left behind a legally valid will. The probate court validates the document, and your chosen executor follows your exact instructions to distribute assets to your beneficiaries. Dying intestate means passing away without a will. The court appoints an administrator, and your assets are distributed strictly according to state laws, regardless of your personal wishes. While probate is common, smart estate planning offers ways to bypass it. The most effective strategy is a living trust. Assets placed in a living trust transferred directly to your beneficiaries, completely skipping probate court. You can also use joint ownership with rights of survivorship, where property automatically passes to the surviving owner. For bank and investment accounts, simply setting up payable on death or transfer on death designations ensures your funds transfer instantly without legal delays. Finally, if the estate value falls below a certain threshold, many states offer small estate procedures. Beneficiaries can simply use a sworn affidavit to claim assets, avoiding formal probate entirely. While a will is meant to be the final word, it isn't always immune to challenges. Contesting a will usually happens under specific legal grounds, like a lack of mental capacity to understand the document. Another common ground is undue influence, where someone maliciously pressured the deceased into changing their beneficiaries. Other challenges include fraud, such as forged signatures, or improper execution, where the document fails to meet strict legal requirements, like missing witness signatures. Proving these claims is incredibly complex and requires substantial evidence, often leading to tense legal battles. Navigating the probate process can be overwhelming, especially when grieving the loss of a loved one. That is why seeking professional assistance is absolutely critical. A qualified probate attorney can provide the personalized legal advice you need to understand the complexities. Additionally, partnering with a financial advisor can ensure effective asset management and safeguard the inherited estate. Remember, having the right expert guidance by your side helps you navigate probate with confidence. Thank you so much for watching. We hope this guide has helped you understand the true meaning of the probate of a will, making a complex process feel a little more manageable. If you found this video helpful, please give it a like, leave a comment with any questions, and subscribe to our channel for more valuable content. For additional resources, comprehensive guides, and dedicated support during difficult times, be sure to visit us at funeralist.com. The link is in the description below. Thank you again for being here. Take care, and we will see you in the next video.